The next case on the docket is the state of Florida versus Clarence Earl Gideon. What says the state? Are you ready for trial?
The state is ready, Your Honor.
What says the defendant? Are you ready for trial?
I'm not ready, Your Honor.
Did you plead not guilty of this by reason of insanity?
No, sir.
Well, why aren't you ready?
I have no counsel.
Why do you not have counsel? Did you not know that your trial date was today?
Yes, sir. I know that my case was set for trial today.
Why then did you not secure counsel to be prepared to go to trial?
Your Honor, I request this court to appoint counsel to represent me in trial.
Well, Mr. Gideon, I'm sorry that I cannot appoint counsel to you for this trial. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. I'm sorry, but I will have to deny your request for appointment of counsel. The jury finds the defendant, Clarence Earl Gideon, to be guilty of the charges. I have no choice but to give the defendant the maximum sentence of 5 years at Florida State Prison.
Recess.
Well, the clock says it's time to close now. I guess I better go now. I really like to stay here all night. The cars crawl past all stuffed with eyes. Streetlights share their hollow glow. Your brain seems bruised with numb surprise. Still one place to go. Still one place to go.
I was sentenced to the state penitentiary by the Court of Bay County, state of Florida. The present proceeding was commenced on a petition for a writ of habeas corpus to the Supreme Court of the state of Florida to vacate the sentence on the grounds that I was made to stand trial without the aid of counsel. The said court refused to appoint counsel and therefore deprived me of due process of law and violated my rights in the Bill of Rights and the Constitution of the United States. Sincerely, Clarence Earl Gideon.
All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States, I admonish to draw near and give their attention, for this court is now sitting. God save the United States and the Supreme Court.
We'll hear the argument first today in number 372, U.S. 335, Gideon v. Wainwright. Mr. Fortas, you may proceed whenever you're ready.
Mr. Chief Justice, and may I please the court. One of the fundamental ideologies the United States lives by is the equality of man, which stated in the 14th Amendment. In an equal society, there should be no leg up for the rich versus the poor. But just 20 years ago, the Supreme Court ruled that this wasn't the case in Betts v. Brady. In said case, it was ruled that a person or persons does not have the right to counsel in non-capital cases. This ruling is illogical and should be overruled here today.
What makes you say this? That the ruling is without logic?
Well, the Sixth Amendment is what is in question in this case. And nowhere in that amendment does it distinguish between the right to counsel only in capital cases versus non-capital cases, nor does it give a distinguishment in the 14th Amendment.
A person does not have the right to counsel as stated in Bettis versus Brady. In this case, it was ruled that a lawyer could be appointed if there were special circumstances, and Mr. Gideon did not have nor claim any special circumstances that would have deprived him of a fair trial.
What sorts of circumstances would have required the appointment of counsel?
A
person does not have the knowledge of a lawyer that has studied law for over half a decade, and thus does not have the skill nor resources required to build and support his own case. This is inadequate This inadequate defense is a deprivement of a person's ability to stay out of prison.
It is perfectly fair and reasonable for a person to defend themselves in court. This is due to the judge himself. A fair judge who knows law should and is capable of giving a defendant a fair sentence regardless of his representation in court.
The right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. From the very beginning, our state and national constitution and laws have laid great emphasis on procedural and substantive safeguards designed to assure fair trials before impartial tribunals in which every defendant states equal before the law. This noble idea cannot be realized if this poor man, charged with a crime, has to face his accusers without a lawyer to assist them. With this in mind, the court rules in unanimous decision in favor of Clarence Earl Gideon. With us today, we have former lawyer Louis L. Wainwright, the prosecuting lawyer of the case Gideon v. Wainwright. Good morning, Mr. Wainwright. It's been 50 years since the Gideon case. Did you anticipate it would turn out the way it has?
No, at first I didn't think it was going to hold up, but I must admit it was a cause for celebration, a just cause. But what's happened since has been enormously disappointing. The fact is, the promise of Gideon has not been fulfilled.
How not? What happened?
They didn't provide enough money, enough lawyers to give people who are convicted adequate representation and assistance. Very few of them get lawyers who have the time to do the work. The lawyers themselves don't often care to do the work due to that lack of pay. Unfortunately, not enough states have the funding to do the job. It's really a sad story. It's a travesty. Gideon was wonderful. It really sent the message that the United States was going to treat people that were poor in a kind way. But it just hasn't worked out that way.
Deep in the back of my mind is an unrealized sound. Every feeling I get from the street says it soon could be found. When I hear the cold lies of the pusher, I know it exists. It's confirmed in the eyes of the kids, emphasized with their fists. But the high has to rise from the low, like volcanoes explode through the snow. The mosquito sting brings a dream, but the poisons derange. The music must change, for we're chewing a bone. We soared like the sparrowhawk fly, then we dropped like a stone. Like the tide and the waves, growing slowly in range, crushing mountains as old as the earth. So the music must change, change. Sometimes at night I wake up and my body